talk to us about the origin of these employment claims.
Yeah, so there are many suits that Uber is settling, I would say, for a bargain. The $20 million is a bargain for Uber. They were brought, I think the central suit was brought in 2013, and this is the time where, right, Uber's just getting rolling here in San Francisco in particular, and there's this tension over whether or not they should be treated as employees or, as Uber has maintained all along, as independent contractors. That's the origin of the central suit.
So the lawsuits were promising. Why are they getting away with settling for a bargain?
Well, in one word, it's arbitration. So Uber has contended and fought and won with the help of an appeals court, and I should add, the Supreme Court with the help of Neil Gorsuch and appointed by Donald Trump, with rulings that have upheld its arbitration agreements. So Uber has made it difficult to opt out of arbitration. If you want to work for Uber, the general course for most people is that they sign the agreement, they start working, and they're bound by arbitration, meaning that they can't take their cases or their conflicts to court. They can't band together in class actions. They have to fight one-on-one behind closed doors of arbitration. And courts have kind of consistently upheld Uber's right to do that. And that's the weapon they've used to kind of blunt these lawsuits.
Now, that said, there was a ruling in California about a company called Dynamics, right? It's a trucking company, had to do with their drivers, where they did rule that those contractors should be treated as employees, correct?
That's right. And that's kind of, if you're a worker, if you're a driver for Uber hoping to get the benefits of employees one day, this is now your big hope. This is a California Supreme Court ruling last year that the court said applies broadly throughout the economy. We're still looking. It's still early on that ruling, and cases are kind of working their way up. But this is the one kind of, as Uber is taking the company public, this is the one concern that people haven't maybe paid enough attention to for the business model going forward.
So how could that ruling affect Uber?
Well, the same way that this case did, only it would be, it's much more difficult for Uber to get out from underneath the Dynamics ruling. So the ruling would say, look at under the relationship that you have with your drivers, under that relationship, these drivers are employees and they're entitled to the benefits under Dynamics. So that's a different ruling, and it's much more rigorous. It's much more difficult for Uber to get out from underneath with its arbitration agreements.
And what about the broader employees of the gig economy?
Well,
right? I mean, Uber isn't the only company. Of course, there's Lyft, there's Instacart, there's all of these companies that employ many, many, many contractors.
Absolutely, and this was the case that was like we're talking about Uber, but this was the case that we've been talking about that was settled that many looked to for the broader gig economy. Now that case is against Grubhub, and it's before the Ninth Circuit Court of Appeals here in San Francisco. This summer, we're going to have a key hearing under Dynamics. That's what they're looking at. They're looking at this Grubhub case. And the rules under the Dynamics ruling that we've been discussing as the future of how the gig economy is going to sort out and whether or not these employees are independent contractors or one day maybe employees.
So the fight for drivers to get employee status and the benefits that come with it, that fight is ongoing. It's not over. Is that what you're saying?
It's not over. It's not over. It's not over. It's gonna continue, and I think it's gonna be a more fierce fight. For the time being, Uber's glad to have this one done, put it aside, go public, and
for
fight
a bargain, as you say.
For a bargain and fight the fight down the road.